Hello and welcome to the Herrington Carmichael Employment Law Update for February 2019. My name's Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and as always I have the four latest developments in the world of employment law to bring you. So let's start with the issue of executive pay. In the last month, a new set of regulations have been announced whereby, with effect from January 2019, companies which are listed and have more than 250 employees are going to have to publish the difference in pay between their chief executive or board members and their average employees. If you're a listed business, this is something to look out for, it's something to take some guidance on, and it's something which we expect to see developing into other business areas in the coming years, so watch for this one coming. Next is a whistleblowing case. This involves the matter of Ibrahim and HCA International. Whistleblowing is a situation whereby an employee makes what's called a qualifying or protected disclosure that there has been a breach of the law by their employer, and as a result they've been treated less favourably. In this case, Mr. Ibrahim tried to argue that there had been an act of defamation, and that the defamation itself and his complaint about it afterwards was the qualifying or protected disclosure. However, the Employment Appeal Tribunal said that no, that wasn't the case, and unfortunately in this case for the employee it wasn't a qualifying disclosure because it wasn't made in the public interest. And this is important for employers because remember, where an employee makes a complaint of public interest disclosure, it must be in the interest of the public and not for the individual concerned. So that case he lost. However, keep a close eye on it because there can be circumstances potentially where it may have a broader implication and you may find that there is a proper protected disclosure and a whistleblowing claim available. Be careful, basically. Next, the case of Chatfield, Roberts and Phillips. This is an unusual scenario involving an individual who argued that they were an employee, and the question was whether substitution could give rise to a self-employed rather than an employed situation. For those of you who have been watching the developing case authorities, you'll know that substitution normally is a situation where it's always going to be self-employed. However, on the facts of this case, it was found that actually substitution did not undermine the employment relationship, and as a result Chatfield Roberts was an employee. It's something to be really careful of, and it's something which we see a lot of employers and businesses looking at carefully. And if you have a situation where factually you may think somebody could be an employee and that's a relevant factor, it's an important situation to take some advice. Finally, the case of AVU and PwC, which relates to the Publicity of Employment Tribunal judgments. As many of you know, since about 2017, the Employment Tribunal judgments have been published online, and in this case the claimant tried to get rid of that judgment offline because it made some derogatory statements about them. Unfortunately for them, there was no public interest and no reason to remove the judgment from being online, and as a result the judgment remains in place. It's an important warning for both employers and employees who pursue claims that these are public judgments and you have no choice about what they say. So ultimately you're stuck with criticism. That's it for me this month. If you have any questions at all, please don't hesitate to contact us, otherwise I'll be back in March. Thank you.